All right, we're off to a roaring start this morning. I want to thank you all for coming to this House Judiciary 2 Committee meeting. I want to first introduce our Sergeant at Arms. We've got Bill Bass, Teresa Ferguson, and Marvin Lee. Thank you guys for helping us out. We don't have any specific pages, but we have an honorary page today, and I'm going to recognize Representative Miller to identify his honorary page today.
Thank you, Madam Chair. It's an honor to have Mr. James Kilty from Southport Christian School in my district with us today. So welcome, James.
Welcome, and thank you for joining us. We hope you get a lot of good experience today. We seem to have the most desire to speak on House Bill 44, and I don't see the primary bill sponsor here, so we'll hold that one open. And we will go to, let's see, it's Representative Jackson. Representative Jackson, if you want to come forward, we'll let you present House Bill 87. You're welcome to come up here. We usually have people present from the podium and save that for people who want to just speak. House Bill 140. All right, thank you. Go ahead. The floor is yours to present your bill.
Thank you, Madam Chairwoman. House Bill 87, brought at the request of my district attorney, Andy Gregson, and the Conference of District Attorneys. Bill places into statute what is common practice, but just brings clarity to the courts regarding continued jurisdiction over a defendant that has pleaded guilty and agreed to a probation sentence. Just to put it into common layman terms, you have originating county, you have supervising county. So someone is convicted and placed on probation in originating county, but you have a supervising county where the probationer is residing, and a lot of times they'll go to a larger county where they can have more freedom, if you will, but they'll come back to the originating county and do some unlawful things, if you will. And so this bill just clarifies, gives originating district attorney authority to cite the offender. He already has authority to hear the violation. It just clears up things so that he can cite the offender.
All right, thank you. Do we have questions of the committee? Representative Moore.
Thank you, and appreciate the bill. And just for clarification, so if we have the originating county, for instance, someone is sentenced in Orange County, and then they transfer probation to Durham County, and the probationer gets in trouble in Durham County. So which DA would have the authority to cite the probationer for a violation? Would it be either DA?
Either.
Okay, and if there's also the infraction or the violation occurred in Onslow County, would that be a third DA that would have the ability to cite a probation violation?
Yes.
Yes, ma'am.
Okay. Wouldn't that cause a lot of confusion?
We have the Conference of District Attorneys wanting to speak on this bill, and that may be a more appropriate suggestion. Further questions or comments before we go to the Conference of District Attorneys? Any member? All right. Chuck Spahos, you are recognized to speak on House Bill 87.
Thank you, Madam Chair, members of the community. I'm Chuck Spahos, General Counsel for the Conference of DAs. If I could address Representative Morey's question, current statute says that authority would vest in 3 counties, just as you laid out. In the county where the probationer committed the offense, in the county where the new person is being supervised, and then in the convicting county. So that is, the court currently maintains all 3 of those jurisdictions. This is just to clarify that if a given county where supervision has transferred to has a policy of, for instance, waiting until there's a new conviction on a subsequent felony act. And that subsequent felony act occurs in the county that's conviction that has a policy of bringing the action once there's been a new subsequent act, that DA can file that petition there.
Do you yield for questions?
Yes, of course.
Representative Moore, do you have a question?
Thank you. Under current practice procedure law, the probation officer could still be citing that person for whatever violation, wherever that probationer is.
They certainly could, yes, ma'am.
Now, this would give the possibility of 3 possible DAs having the same ability to cite that petitioner for some violation of probation.
It would actually this is aimed at the DA in the county where the conviction took place. You're right. The general practice is that the probation officers bring the action and the prosecutor just steps in and prosecutes it. This just clarifies that it can be brought by the prosecutor even if the county where residence has transferred to doesn't have any interest in bringing the petition right now.
One more question.
You're recognized.
Sorry, thank you. Am I correct that reading this new provision that any of these DAs would also have the ability to cite the probationer to revoke, modify, change any type of the original probation order by the originating judge?
That's correct. If there was a condition of the probation from the convicting court and they move to a different county and there is a subsequent violation of the terms and conditions of probation, the sentencing court's district attorney could bring the petition to put it in front of that sentencing court that already has the authority. So it's a matter of getting it in front of the judge that already has the authority under 1344.
Okay. If I can have just a moment. I think staff disagrees with Chuck Spahos. So I recognize Susan Seitz to give you Legislative Analysis Division because we may want to make corrections if you think it's that way or we want to get clear what the bill says
Sure.
based on legislative
I'll definitely
analysis.
defer to Susan.
Thank you, Madam Chair. Susan Slice, Legislative Analysis. Mr. Spahos is correct that a court in any of those, say, 3 counties would have jurisdiction, but the bill only authorizes the DA in the county where the probation was imposed to file this motion.
That's right.
So it does not allow, like in your example where they were imposed in Orange County on probation in Durham County, it would only allow the Orange County DA to file this motion, not the Durham County DA where they were on probation. That's what the bill says. Now, if that was not the intent, then...
No, that is the intent.
Okay.
I'm sorry. I misspoke if I said otherwise.
Further questions about that? All right, seeing none. Any further questions? And this is the only person I had signed up for public comment. So,
A motion.
Representative Smith, you're recognized for a motion.
Move for a favorable report to House Bill 87 with the referral to rules.
You've heard the motion. All those in favor say aye. Aye. All opposed, no. The ayes have it, and the bill will be so reported. Wanted to recognize Representative Biggs, who's also here and was part of this bill as well. Thank you for coming. Next, we'll do House Bill 125, and there's a PCS, and without objection, the PCS is before us. Representative White, Representative Bradford, and Representative Rydell. It appears only Representative White is here, so you are recognized to present the bill.
Thank you, Madam Chair. Those of you that were here in the last session, you voted unanimously for this bill. It then ended up in a very pleasant place in the Senate trash can, where it still remains. And I think because it's now March, it cannot come out of that trash can, so we have to do it again. The Safe Surrender Bill is in place and has been in place since 2001. And it allows a mother who has had a baby, 7 days or younger, to surrender that child. And this protects the mother and it protects the child. So currently the bill is strong and that's what it does. But this current edition allows a few more, a little bit more safety for the surrendering mother. And it allows for, and let me just state the 4 things it does. very quickly. It changes the immediate response of the Department of Social Services to the surrender, and it changes the court process and requirements for these cases in a manner that strengthens protections for the surrendering parent's identity. It also removes the surrender to any adult, which it now says, the current bill that's in place since 2001, says that the mother can surrender to any adult. This bill says that this PCS says that the surrenderer can only give it to a person on duty, as a healthcare provider that's on duty, a social worker that's on duty, and first responders, including law enforcement, emergency medical workers, and firefighters. These professionals are already also listed as folks that can take it from the surrendering mother, that can also give it to an adult that can give it to those folks. The third change is the bill adds to the law providing information to a surrendering parent regarding consequences, rights, options related to safe surrender, about services that may be available to the parent and infant, as well as information about how and when they can seek to regain custody if they change their mind. Under this bill, information would be developed by the Department of Social Services that can be downloaded and used by professionals designated as eligible to accept a surrendered infant and would be also available to the public. The fourth and last, this bill also incorporates provisions to ensure that protection offered by the law with respect to identity and immunity from prosecution for the surrendering parent are only applied when the safe surrender criteria are met, which is the infant can be 7 days or younger without signs of abuse or neglect as determined by a healthcare provider. If there is a reason to believe the person surrendering the infant is not the infant's parents, or that the parent intended to return for the infant, the law will not apply. The bill addresses the non-surrendering parent's rights as well, including provisions about the non-surrendering parent. The North Carolina Supreme Court opinion in EB 375 NC 310 2020 that discussed the constitutional rights of a parent who did not execute a relinquish for their child's adoption. And this last one about the non-surrendering parent's rights comes from that statute.
All right. Thank you. Members of the committee, do we have any questions or discussion? Representative Willis.
Thank you, Madam Chair. Thank you, Representative White, for bringing this forward. One question I have is, you mentioned 7 days a moment ago. Is there a reason why we've limited it to just 7 days?
The original bill in 2001 referenced a week, so this is just kind of a reframing to assure that the 7 days, the child cannot be any older than 7 days. And that has been... I think the originators of the bill in 2001 felt like, and I agree, that if a mother is going to usually dump the baby, it's usually in that first week. So if we give them that opportunity to not dump the baby, but to give it to someone who is a professional that can help, process the child's care from that point on. If the child is older than that, there may have been abuse or neglect. So then that enters into a whole different level of issues, legal issues. So rendering at 7 days or below hopefully gets that mother that's just a teenager, someone who is just so drastic for their maybe thinking about suicide themselves, and they used to put it in the dumpster, now they can put it in hands of someone who can help take care of it.
Okay, thank you.
Further discussion?
I have one more point I can make.
You go ahead. You may make your point.
We allow also up to 60 days for the surrendering parent to make a decision to go back into the system and be able to retrieve the child if nothing, abuse, neglect, or any other issues have not occurred.
Representative Butler.
Thank you. And so just one quick thought. So after the 60 days expires, Representative, then the surrender would be processed through a typical termination process.
Exactly.
All right. Thank you.
Further discussion? Further debate? Seeing none. Representative Green, you're recognized for a motion.
Yes, I'll move for a favorable report to House Bill 116's proposed committee substitute with a referral to rules.
Unfavorable to the original.
Unfavorable to the original.
It's 125 instead of 116.
Yes, I'm sorry, it's House Bill 125.
125.
Okay.
I apologize.
The motion for
Jumping ahead.
clarification is a favorable report to the PCS for House Bill 125, unfavorable to the original with a referral to the rules. That is the motion. Any further discussion or debate? Seeing none. Those in favor will say aye. Aye. Those opposed will say no. The ayes have it. The bill will be so reported. Thank you, Representative White.
Thank you. Thank you all.
We will do House Bill 140, civilian traffic crash investigators. Representative Faircloth, you are recognized to present your bill.
Thank you, Madam Chair. This bill that's before you is requested by municipal police served towns and cities. There's only one that has actually asked for a particular way of addressing this, but I understand other cities and towns may have talked about it. Greensboro has requested that this be put before you, and one of the primary drivers of this is the fact that virtually every law enforcement agency is losing people, losing employees, or failing to be able to refill vacancies that they have. And so they're looking for ways of trying to keep enough action on the street, if you will, by the police agency or whatever their law enforcement agency might be. And this is what that particular city has studied and put together. And this is, they're asking only for them. But the way it's written, it would apply, it would make all the cities and towns able to use this.
And before we go much further, would you like to send forth your amendment?
Yes, I guess I better do that.
Okay. Representative Faircloth wants to be recognized for amendment. I believe all members have copies. Representative Faircloth, if you'll explain your amendment.
The
Training designed by Justice Academy.
each,
I'm sorry, is this your amendment, or is it Representative Green sends forth this amendment? Would you like Representative Green to explain his
that'd
amendment?
probably be good.
Representative Green, you're recognized. You can do it from there.
Yes, and I think Representative Faircloth, he and I have consulted about this amendment, and I think he considers it a friendly amendment. And what it seeks to do is start to establish more or less a standardized training program for these civilian traffic crash investigators statewide, rather than leaving it on a city-by-city basis, because it seems like we're authorizing that more and more of these are coming into existence. So that would be the substance of the amendment.
Any question or discussion on the amendment? Seeing none, the question before the body is the passage of Representative Green's amendment. Those in favor will say aye. Aye. Those opposed will say no. The ayes have it, and the amendment passes. We're back on the bill as amended.
Back on the bill. This proposed committee substitute indicates that municipalities are permitted but not required to establish police departments. Municipalities that do not establish police departments leave responsibility for investigating to the county. Municipalities that do establish police departments generally task municipal police with investigating crashes and reports made by anyone other than law enforcement are currently not admissible in criminal civil court. The gist of this is that this will permit but not require municipalities to hire civilian crash investigators. It's their decision. Direct cities to establish standards and training programs for civilian investigators. Establish meaning that either they would make within their agency a training that is acceptable for it, or else tied into some of the state's training. Direct cities to issue credentials and uniforms to civilian investigators that are distinct from police credentials and uniforms. Would allow civilian investigators to be issued cars with red flashing lights but no blue flashing lights, and with no markings that identify those vehicles as police vehicles. So these are civilians, not law enforcement officers. Would authorize civilian investigators to write reports but not authorize them to carry weapons, perform arrest, or issue criminal process. Authorize civilian investigators to tow or remove vehicles obstructing public streets. Now, please keep in mind that this particular request is for a municipal type situation. It could be applicable to sheriffs if they wanted to. It could be applicable to others, but it is at this point a municipal situation, and the municipality would be responsible for structuring their particular group so that it has the level of training that is necessary and that it is appropriately protecting their citizens in this city. I would be glad to answer any other questions.
All right, other the questions. Representative Butler.
Thank you, Madam Chair, and thank you for the bill, Representative. This is a bill that comes after a pilot program was established in Wilmington, North Carolina, which is my district, and it has been wildly successful. It has allowed police officers to attend to more serious matters. The crash investigators, all in the case of Wilmington, are all retired police officers, so they're very well qualified to do this work. And as it stands right now, they are civilian crash investigators. They're not permitted to write citations. I think my municipality would like to serve as the pilot to allow those civilian investigators to actually write the citations. What they're doing now is the police officers are actually returning to the scene in the event a citation is necessary, or sometimes I think they're even zooming into the site. So it's a good bill. It is helping with resources. It is putting police officers where they need to be, and Wilmington thoroughly endorses it.
Thank you. And I know that writing infractions is a very controversial issue. Representative Morey.
Thank you, Representative Faircloth. I won't mention my city's name, but I know they asked for us to also support this bill. Just a practicality question. If someone is in a wreck and they call 911, would the dispatcher be the one to determine if a law enforcement official needs to go or a civilian traffic investigator needs to go, or would law enforcement be deployed and they would call the civilian investigator?
Everybody would be free to have their own system, but as I see it as an old cop, the communication going in, whether it be from a citizen that drives by and sees an accident, whether it be somebody who was in the accident or called, however the information got to the police department, then they would assign based upon what that information was. And if it was not appropriate for the civilian investigator, they would not be sent. If they did send them, and when they got there and they saw that this was more than just a bump up, there is somebody injured, or there is somebody that's emotionally having a problem or whatever, they immediately would see that information gets back to the department, and an officer would come for that. And of course, it all depends on where that their people are as to how long it takes them to get there. All the same troubles we have now with managing a large police agency. But I think this will help. As was said, there are a lot of experienced retired officers who are either giving time or being hired to do this type of same thing. Of course, they have been trained in the past, but this is simply a way of trying to help with the number of officers on the street out there. If you don't let somebody like this do it, that officer is going to have to be pulled in, and just as we have always done in the past.
Further questions? Representative Pirtle.
Thank you, Madam Chair. Representative Faircloth, thank you for bringing this bill forward. As a former police chief, I've been contacted by numerous chiefs from around the state asking for this type of assistance. I know, albeit it might not be a strategy that I used in my department, I do understand with staffing levels that exist now, especially in larger municipalities, how this right here can assist the calls for service, addressing the calls for service volume, and realistically they're collecting data for a DMV form on property damage only. So I think it's a very logical thing to do. Thank you very much.
Representative Butler.
For a motion at the appropriate time.
All right, we have one person signed up from the audience to speak, so any members of the committee wanting to speak further or ask questions? Marie Evatt, you're recognized. You'll identify who you're speaking on behalf of.
Marie Evatt, I'm with the North Carolina Sheriff's Association, but today I'm speaking for Fred Baggett from the Chiefs Association. He's unable to be here today, but wanted to extend his thanks to the bill sponsors for this bill. The Chiefs Association has been working on this issue for several years and very strongly support this legislation, and I'm happy to speak on their behalf today.
Thank you. Any further questions or discussion? Representative Butler, you're recognized for a motion.
Thank you, Madam Chair. I would like to move for a favorable report to House Bill 140, the proposed committee substitute as amended.
Rolled into a new PCS.
Rolled into the new PCS, unfavorable to the original with a referral to Rules Calendar and Operation of the House.
Thank you. You've heard the motion. Anybody need me to repeat it? All right. Those in favor will say aye.
Aye.
Those opposed say no. The ayes have it, and the bill will be so reported. Next, I'm going to thank you for your presentation. I'm going to move to have Representative Miller take the gavel, and we're going to proceed to House Bill 44. Representative, I'm involved, as well as Representative Alexander, Representative Sane was here, and Representative Brown. All right.
Okay, House Bill 44, Representative Stevens.
First, I have an amendment, and I believe it's been passed out to the committee. Speak on the amendment?
Yes, ma'am.
This was trying to clarify the language. We sent this bill out one time before, the constitutional amendment out one time before, and people thought you ought to have to be literate to vote, and therefore it was defeated. We're trying to work on this language to get it to where people understand that it's not about really being able to read and write, but it's about that the Federal Voting Rights Act of 1965 prohibits implementation of this requirement, which again, we're going to work on still refining this language a little bit because we want it to be clear that what we're doing is trying to comply with the federal requirements. And so I'd ask for the adoption of the amendment.
Any questions? Motion.
Move for adoption of the amendment.
Move for adoption of the amendment.
Yeah.
Representative Willis.
Yeah, motion to adopt the amendment.
All in favor?
Aye. I'd like to see if the bill sponsors, let them speak on the amendment. I'm sorry, what? Oh.
All opposed?
All opposed? Sorry.
The motion carries.
Motion carries.
Okay, thank you. Staff keeps us on our toes. All right.
Thank you, Madam Chair. The House has long had a general consensus that section of our Constitution that deals with the literacy test is outmoded. those of you who are who understand in history know that it was instituted in the first place right after the Wilmington riots, and it was instituted primarily to cut down on the ability of African American citizens to be able to vote. The kind of poster child case that many of you may remember is Henry Fry. Henry Fry was a distinguished member of this body, went on to have a stellar judicial career, and when he first approached a registrar to become a registered voter in this state, was turned down based upon his literacy test. The essential problem with that test is anybody who has to approach a registrar is required to read a section of the Constitution to the satisfaction of that registrar. That is about as subjective a test as you can have in the 21st century. And so I urge you once again to signal to our colleagues across the fountain over in the Senate that the House still has a consensus that this needs to change and needs to come out of our Constitution. Madam Chair.
Representative Brown.
Thank you. I would just echo the points that Representative Alexander made and say that I do believe from talking to some of our colleagues over in the Senate and hearing some comments they've also made, I do believe the stars might be aligning this year for this to be us to finally get this done and move on from what's happened in the past. And I really think it's incumbent on all of us on both sides of the aisle here to make sure that we're going back into our districts and informing our constituents and people across the state about the true purpose of this bill so we can make sure we can get it finally over the finish line. We've got the hurdle here that we deal with politically, but then we also have the hurdle that we have to go back in our districts and get it on the ballot and make sure it passes on the ballot. It makes our state look great. So looking forward to that. And thank you all for y'all's time today.
Is there any discussions or questions from the committee? We have 3 people that have signed up to speak. First will be Andy Jackson. If you go to the mic, please. Be allowed 1 minute. And identify yourself, please.
Andy Jackson with the John Locke Foundation. I'm rising to speak in favor of House Bill 44, the constitutional amendment to repeal the literacy test. No one here obviously needs a history lesson on how the literacy test was used to strip the voting rights of Black North Carolinians, and I applaud the current General Assembly for taking this bill up. I've also come to offer a warning. Passing this repeal is not a slam dunk. The General Assembly tried, put it up to a vote of the people in 1970, and it failed. There's not a guarantee that it'll pass this time either. I've seen the polling numbers. I saw with 55% support. The rest either did not support repeal or were unsure. That is an uncomfortably close margin. I think the change in the language is a step in the right direction, and I would urge all of the folks here, including my brothers and sisters in the nonprofit community, to avoid trying to use repeal as a political bludgeon. There's a temptation, I think, to try to use any tool you can to attack your opponents in an upcoming election. And if this is used as one of those tools, you could inadvertently drive support down. Thank you for your time.
Thank you. Jason Hensley. Can you identify yourself, please?
Good morning. My name is Jason Hensley. I serve as the Executive Director of the North Carolina Bar Association. I'm here to speak in support of the repeal of the literacy test from the North Carolina Constitution. In 1899, recently elected attorney legislators, many of whom also participated in the founding of the North Carolina Bar Association, drafted the language of the literacy test together with a poll tax and a grandfather clause, which were made a part of the state constitution in the election of 1900. The provisions were together intended to disenfranchise black citizens from their right to vote and restrict their involvement in politics while limiting the impact of provisions on white citizens who could not read. The language of the literacy test, while seemingly direct and requiring that someone be able to read to vote, instead placed significant arbitrary power in the hands of individuals that registered voters, and that power was used effectively for decades to deny black citizens their right to vote. While not currently operable due to federal law, the literacy test serves as a continuing reflection of disenfranchisement and racism. Our Constitution should instead reflect the values and beliefs of the citizens of our state and a commitment to justice and equality that transcends the passage of time. The people of our state deserve a Constitution that is reflective of their goodness and the goodness that they aspire to, and as such, the literacy test should have no place in this agreement between the good people of our state. We ask that you advance this bill to repeal the literacy test, and our organization stands ready to help advance this effort. Thank you for this opportunity to speak.
Thank you, sir. Carol Marino. If you'd identify yourself, please.
Good morning, members. My name is Carol Moreno. I'm with Democracy North Carolina, and I just want to express Democracy NC's appreciation to the bill sponsors for reintroducing this bill this legislative session. Also want to echo what the John Locke Foundation just shared in terms of polling that has been done around the literacy test repeal language. We are in support of the amendment that was just passed so that that language can be clearer to voters in terms of the history that this literacy test repeal has had. And the other thing that I will express is that this bill has been reintroduced in several legislative cycles and hasn't crossed chambers, so we are very hopeful that it will succeed this time around, and would also support the remarks made by the NC Bar Association. So thank you very much for your time.
Thank you, ma'am. Okay, we're back on the bill. Any further discussion?
Entertain a motion.
Entertain a motion. Representative Smith.
Just a question. That was a PCS that was amended, correct? Okay. Mr. Chair, I recommend, ask the committee recommend approval of House Bill 44, the PCS to House Bill 44 as amended, rolled into a new PCS unfavorable to the original with a referral to rules.
You've heard the motion.
You've heard the motion. All in favor?
Aye.
All opposed? Ayes have it.
Thank you.
Thank you. Thank you.
Last bill.
The last bill is House Bill 116. Representative Stevens.
Thank you, Mr. Chair. This bill comes to us from the Conference of District Attorneys. Section 1 is temporary assistance for district attorneys. It's a recognition of a common practice that they've been using, but gives clarity to what a district attorney can do when they have a conflict of interest or for other good cause need an independent prosecutor. AOC has the appointment power, but coordinates with the Conference of District Attorneys to identify a willing prosecutor. Compensation and allowances of district attorneys and their staff. Currently, there are two kinds of district attorney employees, the DAs and the assistant DAs provided statute, and they're all attorneys, or the support staff, which are administrative assistants, legal assistants, and investigators as allocated by the Administrative Office of the Courts. This bill has them all recognized in statute and clarifies the General Assembly in the current Operations Act will provide for the numbers and salary of each position. This bill does not seek to add positions, just to clarify them. And this was brought to them by Administrative Office of the Courts so that they would get that kind of clarity. The district attorney investigators, during the last budget, the last of the district attorneys actually received investigator positions. Now every office has at least one DA investigator. This removes any kind of archaic reference to the district numbers that are no longer necessary and uses the word investigator instead of investigatory assistant, as these positions are not attorneys. Section 4 clarifies that when a district attorney or their staff asks for legal advice from their attorneys at the Conference of DAs, they can do so as keeping it confidential. The conference has various experts in the field and support the district attorneys and give counsel and advice when needed. They treat the relationship like any other attorney-client privilege in any other setting, and this will encourage the communication and requests for help and avoid district attorneys and their staff from making some difficult decisions without the benefit of counsel. Section 5 clarifies that criminal investigations and criminal intelligence shared between the district attorney and the staff members of the conference are protected as part of that confidential investigation. Section 6 modernizes the conference director statute. It had not been modified since 1983. At one time, an executive secretary was what was needed. The current Conference of DAs consists of multiple resource prosecutors specializing in all criminal law areas. Today's practice is an executive director with extensive prosecutorial experience to serve as the head of the agency. The language related to longevity recognized that this position is treated like all the other prosecutors and public defenders in the state and must be an experienced attorney. It does not cause any additional money because the current executive director continues to serve as a resource prosecutor and is already eligible for the same longevity. It recognized the requirement of this post going forward. Section 7 changes how AOC reimburses witnesses for the state and allows the advanced purchase of travel to facilitate witness travel in certain circumstances and within state guidelines and the Administrative Office of Court's policy. What has to happen now is that when a witness can't afford to travel, a DA or an assistant DA has to come out of pocket to pay for it and hope to be later reimbursed. This request also is a joint request from the Administrative Office of the Courts as well as the conference. Section 8 and 9 are a waiver of dispute resolution fees for mediation of district court criminal cases, keeping these cases out of criminal court. The current fee has been shown to be a barrier sometimes to getting those cases resolved to the local court-approved service providers from serving as mediators in the case that would otherwise result in arrest and bog down the criminal system. Currently, the court can waive a fee on an individual basis. This provision clarifies that the court can find that a legitimate provider, upon agreement with the district attorney, can mediate these cases without collecting a fee up front for an entire class of cases. And Section 10 simply is the effective date. I will stand for any questions.
Any questions? Comments?
We have one speaker.
Have one speaker signed up, Chuck Spahos. Okay.
All right.
Any further comments? Entertain a motion.
And it is a PCS, which is before us. No, is it? Yeah. No, it's the original bill.
PCS.
It is a PCS.
It is PCS.
The PCS is before us without objection.
PCS before us without objection. Representative Butler.
For a motion, Mr. Chair. I move for a favorable report to the proposed committee substitute of House Bill 116, unfavorable as to the original, with a referral to rules, calendar, and operation of the House.
Heard the motion. All in favor?
Oh,
it goes to appropriations, Representative Butler.
To appropriations.
All in favor? All opposed? Motion carries.
All right, you want to end this? I'll end this.
You can end it.
Thank you, members. That concludes our calendar for the day. Please thank Representative Miller for his first foray as chair. I think he did a good job, and